After you sign them up and they like you, don't tell them how much their case is worth at the beginning. They often ask. I say it'd be irresponsible for me to tell you because I don't know what everything's wrong is, and that would not be appropriate. And you need to manage their expectations. So don't overpromise and underperform. Send them a thank you letter. My new client letter. It's a form letter. It says, "Thanks for hiring me. Really appreciate it. Here's my email address. Here's the things you do and don't do." Don't get on Facebook and say that you're not injured and you're great, and then go to a deposition and say you can't walk. I mean, everybody gets Facebook these days. I specifically counsel people on this. We had a case where last fall my client puts on his Facebook, and they were all over his Facebook, puts on his Facebook post, "So glad to be back to work after my 8-month vacation." I'm like, well, remember, you couldn't work because you were so injured, right? So that kind of stuff. And look, it's important. Lawyers are really challenged in our credibility in the public. So it's really important to have that integrity from the beginning to the end of the case, including with your client, because juries will sniff that out. If you're playing games, they're not going to know exactly what you're playing games on, but they will sniff it out and they will know you don't have that. And so I strongly recommend you do that. And you don't want to have a client who, you don't want to have a client who exaggerates their symptoms and does that stuff. It doesn't help you. It doesn't help you to have that client who is done treated and then a year later says, "Hey, I'm going back. I'm going to get a ton of more treatment." And you're like, "Oh, great." Well, the insurance company ain't going to pay for that. The jury ain't going to believe it. So that may not have that integrity. Lien letters. Send a lien letter to all the people you identified in the case. The lien letter is there. Tell them you have a lien. That's how you get your statutory lien under the attorney's lien statute. Tell them, preserve the evidence in your lien letter. Can't tell you how many times I've taken depots where they say, "Oh yeah, we had the surveillance tape showing that your client fell and it wasn't their fault, but it automatically erases after 30 days or blah, blah, blah." Or you depose the defendant. I did this just 2 days ago. "Yeah, I had all those emails." "Oh, you needed those?" I'm like, "Yeah, I gave you a request for production documents a long time ago." I actually had a case that I tried where the client got up and testified on the stand recently that they didn't produce to me the personnel file in an employment discrimination case about my client. They just never did. So it's important to say to ask them to preserve this evidence, okay? And a lot of times the defendants may have pictures like that. So put that in there. So what if you have the premises case and you don't know who their insurance company is? Well, you send it to the individual, right? You send the letter to the homeowner or the property owner somewhere and say, "Send this to your insurance company." But they don't have to. They don't have to do that. They can stymie you. Then the only thing you got to do is you got to file suit and sue them. And when you're suing them, then they'll see the light and they'll get your insurance, their insurance company. Happens all the time. So you go and investigate the case. Remember that before you file suit, the other side isn't represented, and there's no Rule 4.2 prohibition against calling and interviewing people. So before you file suit, call the witnesses. Call up the person in the police report. Call the employee of the store. Call the store manager. There's no prohibition of doing so if they're not represented under 4.2. The best investigation is done sooner because people forget stuff. Things go away and that kind of stuff. I'm not saying they're going to talk to you or going to want to talk to you, but that's what you should do. We cite the statute in here. There are Unfair Claims Practices Act laws. The laws are better in Illinois than Missouri, but they have to acknowledge your lien in writing. They have to tell you the regs say that they have to tell you the policy limits, but they never tell you the policy limits if you've ever asked. They always don't want to tell you. But actually, in a lot of the regs and a lot of the statutes, they say that you have to, but they won't unless you show them damages that high, so that is a problem. So they will often say, and especially in a slip and fall case, "I want a statement of your client." So what do? So here's what you do. So what I do is I say, I'll let you have a statement of my client. If you give me a statement of the store manager or the person that's at fault. Because what they'll do in premises cases, they'll say, "We can't even adjust or investigate this claim unless you give us a statement about what happened." and then you're like, well, you know, and then they'll stymie you, and then you'll have to file suit, and then you'll be in litigation, which, frankly, that may increase the value of your case anyway. But my response to that is always, basically, you can have a statement of my client if I can take a statement of yours. And it's really effective because it takes the wind out of their sails. They can't use that as a false excuse not to adjust or to pay you on the case. And it almost never happens. Now, there are occasions, you may have an occasion where if you're and you really have to be careful when they want the statement to challenge the liability of the case, to not pay you. If you have an adjuster who you're working with, they kind of say, listen, we knew we had this hole for no reason that wasn't marked in the middle. We just want to make sure your client had some knee problems before. I want to take a statement to make sure that the knee surgery is connected to this, or I want to do this, or I want to do that. Then you may want to give them a statement. If it's someone where you're trying to get to yes, you're trying to get a resolution, you may want to give a statement and have that good faith and work with the adjuster there. It kind of depends. You know, there are good adjusters out there and bad adjusters, both.